Good morning.
Hi, Ms. Kopic.
Good morning. May it please the court. Alice Kopek, Special Assistant Public Defender, on behalf of the appellant, Mr. Johnchuk. I would like to reserve 4 minutes for rebuttal if I could.
Sure.
And in this oral argument, my intention is to focus my argument primarily on the PCLR and the psychopathy issue, unless the court has any questions on my other issues, and I'll rely on my brief if you don't. And in the hearing on the motion in limine to exclude the PCLR test and evidence of psychopathy, the trial court noted that it was a game of semantics, really, to kind of try and figure out why someone does what they do, and that NGRI was really that game of semantics. And of course, we know that semantics is a branch of linguistics that's concerned with the meaning of words, sentences, phrases, any kind of text. It's not concerned with the study of behavior. The game of semantics that was deployed here in this over 10,000 page record is the notion that you can have an expert tell the jury that Mr. Johnchuk killed his daughter, who by all accounts he adored and loved, that he killed her because he was a psychopath, so long as you don't use that exact phrase or those exact words. Because as the court recognized numerous times throughout the record, that it would be horribly prejudicial to simply say that he did it because he's a bad guy and that's why he killed Phoebe. The court also noted it would be very, very, and at one point extremely prejudicial to call him a psychopath. But yet it's okay to let the experts tell the jury everything about Mr. Johnchuk that led them to conclude that he was a psychopath or had a high level of psychopathy, and then that's why he killed her.
And Ms. Kopic, am I correct
Yes.
in understanding that the experts also were of the view that even if that Mr. Johnchuk could be insane or not, regardless of whether he was a psychopath?
That's true, Your Honor, and that does.
Psychopathy is not had no real bearing on their determination that he was or wasn't insane under the test.
That's absolutely true. Dr. Burston himself, in that hearing on the motion in limine, said psychopathy does not rule out insanity. You can have, they're not mutually exclusive. He can have those high psychopathic traits, and he can also be insane at the time of the offense. And I think that's critical.
Or not.
And
he can be perfectly not a psychopath and be insane.
That's correct. That's correct, Your Honor. And I think that kind of goes to the subjectiveness of the psychopathy. You know, for sake of this argument or purposes of this argument, I'll concede even if he was a psychopath, even though, you know, again, it's subjective, but even if he was, that does not rule out insanity. And so exactly that. Dr. Burston said psychopathy does not rule out insanity. That goes to the relevancy argument. Dr. Burston also said I would never, ever profile him and say he did it because he's a psychopath. That would be so wrong, he wouldn't even think of it. But that's exactly precisely what he did, because even in the face of clear and obvious psychosis, which Dr. Burston said he had, he discounted that and said because he had these high traits of psychopathy, I believe at that moment on the bridge, it was a pattern, a propensity, a conformity in his life. So I'm just going to discount the psychosis. And then, of course, he wasn't allowed to say psychopath, but again, we go back to the linguistics. The short lingo for psychopath is psycho. You know, they have, and we go to linguistics, the root word is the same. And so it's clear that the jury understand exactly what they were saying. And
did the witnesses describe the checklist to the jury?
Yes, they did, both of them. So the jury heard it twice. Both of them went through all of those characteristics, which the court recognized and said was devastating, horrible, horrible traits. And not only did the jury hear it once, but they heard it twice.
and they described the reasons why they checked the box. I mean, what evidence did the experts have to cause them to check the boxes?
They did, Your Honor, and I'd like to just preface this with, the court kind of intuition versus execution, sort of minimizing the psychopathy checklist by saying at one point, hey, I could be a psychopath because some of these items are so ridiculous. So kind of minimizing it, but then yet also acknowledging that it's just a laundry list of bad character flaws. So they were allowed to do that. And I believe I articulated it in my reply brief. The problem being with that is, particularly Dr. Burstyn discounted all of the witnesses that he talked to determine this was post-homicide, they're surviving victims, and discounting that they had already talked to law enforcement or been deposed and described psychotic symptoms and the bizarre nature surrounding the time of the offense, which is what is the critical issue. What was his state of mind surrounding the time of the offense? And just discounted all that and gave greater weight to things that he had done 10 years ago, 15 years ago, heck, 20 years ago. And that goes to the subjective nature of it. And then when, the defense, even though they didn't have any burden to prove, it was the state's burden to prove that the PCLR was relevant, reliable, generally accepted in the community, which they offered zero proof. The defendant had no burden, yet they provided ample, substantial evidence that in fact it was not generally accepted in the community. Dr. Burstyn himself acknowledged he had no authority to say that it was generally accepted for use in an NGRI evaluation, and he only routinely used it for risk assessment, which is what the test was designed for. And the defense even proffered articles, a consulting expert's affidavit saying it is not reliable and valid for this purpose. Including the developer of the instrument himself, who said it does not meet the reliability criteria for use in the criminal justice system. And I think one of the biggest criticisms he had was the problem with adversarial allegiance. Whoever hires the expert, the score is going to be dependent on that. And so we have that issue here. It is a subjective test. Dr. Burstyn conceded that it was subjective. And if we go back to, the court's intuition versus execution, the court says no one's going to say that he was sane because he was a psychopath. Of course, without using those words, that's exactly what they did. Because he has these psychopathic traits and in conformity with that personality, that's why he was sane. Well, that's why he did it. He wasn't NGRI, ergo, they were saying, he was saying because he's a psychopath. So then we go back to Your Honor's question. If it's not to prove its sanity, which the state even said we're not using it to prove sanity, then what is the relevance? And then we go to the 403 objection. 403, it has to be any probative value, if there is even any, which I would argue there's not. It has to be substantially outweighed by any undue prejudice. And as I noted, the court recognized how extremely prejudicial this was, highly prejudicial. So taking into account that 403 objection, it's not relevant. Under 403, it shouldn't have come in. But even pre-Daubert, I always forget how to say it, the court abdicated its gatekeeping duty. At the motion in limine, she said the court said it's not my role to determine whether this is a tool valid for this purpose. He relied on it, he used it, so he can testify to it. And that's not even pre-Daubert. It's still, the burden was still on the state to prove that it was generally accepted in that scientific community for that purpose. So the court just abdicated that duty. And again, even though the defendant didn't have any burden to prove, it was the state as the proponent of the evidence to prove that it was, they provided no authority. They continuously said it's the gold standard for measuring psychopathy, but not for NGRI purposes. They provided no authority. Every case law that they cited had to do with risk assessment or future dangerousness. You know, and even in the absence, so even pre-Daubert, you know, we're in a kind of odd situation here where at the time of the hearing, it was Frye. At the time of before sentencing, it was Daubert. So this court is operating under Daubert. The court at the time before it was sentencing was operating under Daubert. And we know post Daubert, obviously one thing is pure opinion is not, you know, is not admissible. And the whole notion of, well, we don't have to prove it's valid for this or reliable for this purpose. Even in the Daubert decision, the court said scientific validity for one purpose is not necessarily scientific validity for other unrelated purposes. The helpfulness standard in assisting the jury requires a valid scientific connection to the pertinent inquiry as a precondition of admissibility. And so it had to be going under the Daubert standards. You know, is there general acceptability? State offered zero proof. Established standards controlling techniques offered zero proof. Known or potentially known rate of error, no proof, and I don't know that they could ever provide any. And then testability of the procedure. Again, it's a subjective test. It relies heavily on the interpretation and the weight that an expert wants to give to collateral sources and collateral information that a defendant is unable to challenge as to its reliability. So, and then in denying the motion for new trial and denying that it, and saying that it would, that the PCLR would satisfy Daubert, the court, again, it cited only cases related to civil commitments, so risk assessment. And it, you know, I agree it has been Frye tested, and she cited cases that it's been Daubert tested for that. And then future dangerousness in capital cases in those states that provide for that. So again, nothing, no proof offered that it was valid for this purpose. And I think the defense's analogy that they use below of self-defense is important in that inquiry, because when you're talking about what is the pertinent inquiry, well, it's Mr. Johnchuk's state of mind. And when you offer self-defense as an affirmative defense, you place your state of mind at issue. And you can't, that the state can't just come in and say, okay, because, I'm sorry. Oh, I thought there was a question. The state can't just come in and say, well, this defendant has a history of aggression. In all of their prior interactions, they were the aggressor. And so therefore he couldn't have had reasonable fear here, or even if he did, discount it because the way that he is in his personality is he's aggressive. You know, I think that analogy is perfect. That's what the state is trying to do here. Instead of relying on the circumstances surrounding this event where there was substantial substantive evidence, not semantics, to say Mr. Johnchuk was in clear and obvious psychosis, which is what even Dr. Burstyn said. You had the 3 defense experts, the 1 state expert who said clear and obvious psychosis, but then he just subjectively pure opinion said, but I'm going to discount that because at the moment on that bridge, I don't believe that that psychosis was present. Again, it just goes to the subjective nature of it. As I argued in my brief, we believe that we've just out, even in the absence of a Daubert hearing, trial counsel provided substantive, you know, through her cross-examining of Dr. Burstyn, through all of the research that she submitted and the affidavit from the consulting expert that showed that this would not satisfy Daubert. The state, again, offered zero proof. And the focus of the inquiry with this court is, you know, who had the burden, and the state had the burden, and there is absolute dearth of evidence that would allow this court to say that the PCLR and psychopathy evidence would satisfy Daubert. In an abundance of caution, so I believe that this court has all of the evidence it needs to say this was clear, egregious error. I shouldn't say egregious, but clear error, and Mr. Johnchuk should get a new trial. But if this court believes, Yes.
Okay, I was having some trouble with my microphone earlier. I finally got it
Right.
working, so carry on.
That was a test.
Sorry, I
I'm a
tried to
guinea
ask a
pig.
question, just to tell you, I tried to ask a question earlier, but you got to what I was going to ask, so we're good.
Okay. Okay. Well, what I was saying was that if for some reason that this court, again, I believe that we have shown, number one, let's take out even if the pre-Daubert and the motion in limine, that the appellant, that the state didn't meet its burden and the court was wrong at the time that it denied the motion in limine. But then post-Daubert, in the motion for new trial and denying it, that the defense had actually given substantial evidence for this court to say, if you don't want to say relevance in 403, well, then post-Daubert, switch to Daubert, then it clearly is not admissible under that standard.
But
But
the
if-
Daubert or Fry inquiry really is important, but it doesn't go to really the relevance, does it? I mean, whether these tests were relevant to a determination of Mr. John Cook's ability to appreciate that what he was doing was wrong at the time, and so under the insanity test, right?
Yes, Your Honor, and that's why I said in this record, it's kind of, I won't say confusing, but it's kind of a back and forth, because that is what I'm saying.
So if you look at if you apply the 403 test and it survives that, then the question is it then Fry versus Daubert comes in terms of whether it's acceptable evidence, basically.
I believe that's correct, Your Honor. Right. Under the 401, 402, 403 analysis, the state didn't meet its burden. And I would also let the court know, 9704 has that, which was changed in 2013. And even at the time that the court was deciding, it has a 403 analysis built right into it. So the court had to conduct that 403 analysis. And that's our argument, is that, this court can put aside right now that Daubert is the rule that you need to apply, because even pre-Daubert and the change at the time that the motion in limine was ruled on, the state hadn't met its burden under 401, 402, 403.
Okay, Ms.
Because
Copeland, you are at your rebuttal time, so you do with your time.
Okay, I will reserve the rest of my time. Thank you, Your Honor.
Right, thanks. Ms. Richards?
Good morning, Your Honor. Cynthia Richards, Assistant Attorney General for the state. I'm not sure where to begin. So let me start by saying, if you look on page 141 of the record, the defense's notice to rely on a defense of insanity, specifically bipolar disorder with psychotic features. And now they're saying we can't say anything about psychopathy.
Well, I think what they're saying is, you went through this litany. The experts go through this litany of basically bad behavior in this fellow's history for a test that, as far as I can tell, and correct me if I'm wrong, you didn't give us any examples of case authority where this test and the factual background for administering it was presented to a jury in an insanity defense case.
Well, Your Honor, let
That's
me.
a big, and the trial judge had a big concern about this. I think quite reasonably so. You're just basically saying he didn't, even though the experts agreed that this test didn't really bear on whether he was insane. So
well, that's kind of the point of using this test, Your Honor. And the example, I believe.
But then they got to say, well, he wasn't insane because he was a bad guy, essentially.
No, Your Honor. In fact, that's exactly the opposite of what was said and why the court allowed it to be admitted. They redacted the checklist, for one. They disallowed any reference to the term psychopathic, psychopath.
Whatever, and you and Ms. Kopek has just a minute ago, I asked about this question of whether the test was presented to the jury. Do you mean they redacted they redacted it on the paper or
Well, the way it's phrased, Your Honor, the way Your Honor actually just phrased it is that it's, as the defense did in their brief, it's a checklist of bad character evidence. And that's not what it is at all. Is if you go into the hospital, the doctor's not going to look at you and go, you're having a heart attack. They're going to rule out angina. They're going to rule out indigestion. And it does bear on whether the defendant was not guilty at the time. And as Dr. Burston went into the, accidentally omitted hearing transcript that was in the record, he went through a very lengthy explanation of why he used this, what he was looking for. And he also went on to say that his diagnosis that he wasn't guilty at the time was because the defense's experts, when they said schizoaffective disorder, schizophrenia, things to that nature, he said, well, that's not medically possible because, and bearing in mind that all mental health is subjective. It's not a biological diagnosis. You can't go in and say you're diabetic, your blood sugar's high. So it is the psychiatrist or psychologist, what they use in their discussions with the person, with the collateral evidence, with their background history, their school, their work, their relationship, all of these things, which Dr. Burston explained to the court that he delved into, is to rule out certain factors. And what he did say was, because schizoaffective disorder and schizophrenia has to have evidence of this more than 6 months from the date of the crime on January 7th. And there just was not that history in anywhere, not in defendant's self-reporting, not in the collateral reporting, not in anything.
okay, so that sounds like admissible testimony.
That's absolutely admissible,
But I don't think that's what the argument's about. I think the argument's about this testimony that he was basically a psychopath and the reasons why.
Except that
which had to be highly prejudicial. I mean, it's just all a series of bad acts, bad behavior.
Well, respectfully, Your Honor, I completely disagree with that characterization because you can't get to, that would be tying the state's hands behind their back saying, we believe, because they have the burden of proof in the NGRI. And that would be saying the state is allowed to say, well, we think he was sane at the time, but now you're not allowed to say why you think that.
Well, that's why these things are very delicate, but that's why I raised the question. Did you give us any case example of the use of this test presented to the jury in an insanity case?
In an insanity case, well, there are basic tests, and this court itself, we're talking about the Fry and Daubert as well. This court, Fry tested the PCLR back in 2003 in Levy State, and it's not subject to a Fry test. You've done that. And under Daubert, this is, and I'm not disputing the fact that the PCLR test is not designed for, and Dr. Burston and nobody ever claimed it is used to diagnose whether somebody is insane under the NGRI at the time of the crime. But like I said, the difference between diagnosing an instant heart attack or eliminating other things first. It's a tool. It's a medical tool like any doctor would use to eliminate other possibilities. And in this case, we're not using it to prove he was not insane at the time of the crime. We're using it to defend the position that this is why we believe he wasn't insane at the time of the crime. Not based on this test alone, but by use of the PCLR as a tool. This is how we arrived at our theory of the case that he was not insane at the time. And so there is a very fine point, and it is distinguishable in the use of this test. And in the lengthy pretrial hearing, Dr. Burston went into, and we want to talk about the 403 relevant evidence. Under 403, it's admissible if the probative is outweighed by the prejudicial, but this is not a Williams rule case. Judge Hellinger made this very clear to the defense again and again and again. We're not talking about motive, lack of mistake, intent. That has nothing to do with this case.
But the Williams rule, the Williams rule does not define of the 403 inquiry. The Williams rule is a specific set of circumstances where the state comes in to try to prove similar bad acts. This was just character evidence, was it not? Which, I mean, it's totally outside of Williams rule anyway.
Well, it is. It's not character evidence.
I mean, to say it's not Williams rule doesn't answer the question, doesn't solve the problem.
Well, that's true, but it's not bad character evidence. It is collateral evidence that the expert used to base their opinion on. I mean, under the rules, that is admissible evidence. In fact, to exclude it would be the exception, not the rule.
Well, maybe unless the prejudice outweighs any probative value when the expert says, yeah, but this test really doesn't tell us whether he was insane.
Well, the problem is you're not talking about the test itself. You're now putting a fine point on the evidence, the collateral witness testimony.
Well, all that came in, you know, as the background for why the doctor checked the boxes on the test.
That is true, but this is the testimony.
So this is what sometimes cases call conduits for otherwise inadmissible evidence.
Except, Your Honor, the problem with this is the state's testimony, Dr. Burston's testimony was rebuttal. And it was rebuttal. We're talking about what Dr. Burston used to form his opinion. However, the defense's own doctors used the same collateral evidence. And it was the defense's own doctors that under which some of the testimony that in fact, the defense objected to their own witness and Dr. Mackless when he got into the defendant saying when he was 12 years old, if I ever did anything bad, I'm just going to say I was insane. That was not Dr. Burston. And if you want to talk about bad character evidence, none of this is bad character evidence. It's not 403. This is just the examination that all of the doctors, not just the states, but the defense, all of the doctors took into account in formulating their opinion. And by making the term, by the way, the psychopathy revised checklist, as I said, their defense is specific on psychotic features. So saying you can't use a psychopathic checklist when their defense is a psychopathic feature of a mental illness would be a little hard to understand. And it's not the name of the test. It's not the test itself. What the defense is actually objecting to is the evidence, the collateral evidence that the Dr. Burston used to formulate his opinion.
Ms. Richards, I want to go back to a couple of points.
Yes.
One is, as I read the record, Dr. Burston was using this as a comparative analysis of what led Janchuk to do what he did, and that it was not McNaughton issues or schizophrenia issues that supported the McNaughton test, but it was these other features that he had. So that's sort of a prelude to my question. This test has not specifically been Daubert tested in the context of evaluating insanity. So if we conclude that this is a new use, maybe it's valid, maybe it's not, would this be correctable by remanding it simply for a Daubert evaluation, or would it be a remand for a new trial?
Well, Your Honor, I would say that in your hypothetical, I think having a Daubert evaluation would suffice in that issue. However, the Daubert standard specifically it provides that expert testimony is admissible if it assists the trier of fact in determining a fact at issue, and it is based upon sufficient facts or data, is the product of reliable principles or methods, and the witness has applied the principles and methods to the facts. So I will say that the last minute inclusion of the hearing testimony, that was a Daubert hearing. Because under that, if what we hold as a Daubert standard now, that's exactly what the court put Dr. Burstyn through. And like I said earlier, back in 2003, this court Frye tested the PCLR and held that it survives a Frye test standard. So now we know that the principles and methods are reliable under this court.
But I guess the question that I'm asking goes to the fact that we know this test can be used to evaluate someone from a psychotic standpoint, but do we know that it can be used to balance against the schizophrenia and whatever other problems Mr. Janchuk had, to say, no, it can't be any of that because psychosis trumps it? I mean, that seems to be what the doctor was doing, was saying the psychotic aspect trumps anything else.
I would disagree respectfully, Judge Silberman. The doctor didn't say that the psychotic features trumps it. And
well, he may not have used that phrasing, but that clearly seems to be what the point of his testimony was. He doesn't meet the McNaughton test because he's psychotic, and he is so psychotic, nothing else really matters. But I recognize Dr. Burstyn also talked about, well, he didn't really demonstrate psychosis, or not psychosis, schizophrenia over a period of time. And schizophrenia normally isn't something that just pops up at the time of a crime.
Well, Your Honor, that's not what the testimony was. The testimony was that the doctor said, well, I'm not using this to see if he was insane or not insane at the time of the crime. He admitted that's not what this test is for. But like I said, it's a tool. It is a reliable mental health tool. And its use was for Dr. Burstyn to figure out what was going on with the defendant's actions. And that's a perfectly respectable use of any tool. Like I said, with other, physical medical thing, you have to rule out, angina before you can diagnose a heart attack. And in this case, he not only explained what he was looking for and why he believed that the defendant had antisocial personality disorder with psychotic features, and clearly the defense, that's not in dispute. The defense said he had psychotic features in their own notice to rely on NGRI. So they're agreeing with us. That's not even a dispute, whether he has psychotic features or not. They say he did. We're only using this test, and along with Dr. Burstyn's other testimony, that this is why I disagreed with Dr. Otto, Dr. Mayer on the schizoaffective or schizophrenic, because this was missing. So the PCLR test, was used in a multitude of ways to help the doctor narrow down the focus of what was going on with the defendant at the time.
But wasn't the testimony designed to basically tell the jury, you can ignore or overcome any testimony as to schizophrenia because psychosis trump? I mean, these are my words and clearly not what he said, but the impact is that the psychosis trumps everything else. Is that not what was being conveyed to the jury?
No, not at all, Your Honor, because the only thing that was being conveyed to the jury was Dr. Burstyn saying, I believe what was going on with Mr. Janchuk at the time was X. He was having a psychotic episode, and this is what I looked at, and this is why I think that way. The doctor also said, he talked about the schizoaffective. That's just his opinion. But what the jury heard, and the jury did have their own questions, and one of the questions the jury asked was, well, can you be insane and have psychotic episodes? And the doctor said, yes, you can. And the jury said, can you be not insane? Is it exclusive of each other? So it's a state's opinion. The jury got the point. They asked the right questions. They examined and took the testimony for exactly what it was meant to be taken as. They also listened to the defense testimony about, this is why, this is the test I used. And the test, it wasn't just the DSM the defense used. Dr. Otto used a multitude of other tests, which were also not designed to determine insanity at the time. It's a tool. It's like having a cardiac stress test and a blood test and an MRI. It's a tool. And all of those things are used by the doctor and was used by the doctor in this case to formulate his opinion. And under Daubert and under 403, but this is not a Williams rule, under 704, it's all admissible testimony. It is absolutely admissible testimony. And the doctor used the test in congruence with the exact same collateral evidence that the defense used to formulate their opinions. It's the same witnesses. It's the same medical background. It's the same school, relationship. All the doctors used the same things and they came to their opinions. The doctor also testified on the stand that you can put 6 doctors, 6 psychologists in a room to look at the same evidence, and there may be agreement on some things and disagreement on other things. That's why, as defense said, of course it's subjective. It's mental health. There is no physical test to determine what's going on chemically inside one's brain at a certain given moment in time. The best you can do is look at everything surrounding it and that person's actions and come up with a reasonable basis for your opinion. Of course.
I don't think you mentioned this, but did the defense doctors talk about John Schuck's psychosis?
I beg your pardon? I didn't hear you, sir.
Did the defense doctors discuss John Schuck's psychotic nature?
They did. In fact, there was agreement by the defense doctors, and off the top of my head, I apologize. I can't remember which one specifically, but they were talking about that the defendant, John Schuck, did have psychotic features, and there was evidence of psychosis. Did
they say that he was a psychopath?
No, nobody ever used that.
Did they say that he had psychopathic tendencies or psychopathic features?
Psychopathic features, yes.
Did the defense say that, or was that strictly
both? Both, Your Honor. That's a medical diagnosis. I know there's a societal sort of knee-jerk reaction to the word psychopathy or
well, I know, yeah, I know that the judge and the attorneys went through, some hoops to try to figure that out, but
that's true. And they eliminated.
To say someone has a psychotic episode is not the same thing as saying they are a psychopath or
absolutely not. Absolutely not.
And that's why I was trying to ask: did the defense talk about psychopathy or psychopathy, as people want to say, versus?
Absolutely, Your Honor. You have to. It's in their notice to rely on the NGRI.
Well, and the reason for my question is there's a point that I'm not sure that you have made, and I want to make sure that I understand this. If there was in John Schuck's reports and in the testimony from the defense that he had these features, then isn't the argument for the state here that the state was entitled to explore that further and how it weighed against the rest of his psychiatric analysis? Because honestly, I don't think you've made that point either in your brief or in the oral argument, and I'm not quite sure if I'm missing something about that.
Well, I mean, honestly, I apologize. I would have thought that is what I was trying to say all along. When they introduce this is our defense, he's got these psychotic features, we think he's not guilty by reason of insanity, and we say, great, that means we get to explore what those psychotic features are, and our doctor happened to find that the psychotic features had more of an effect on his behavior than whether he was insane at the time or not. So the state absolutely has a right to rebut their theory of the defense. And if their theory of the defense is that he was not guilty because he was insane at the time with psychotic features, any examination of their doctors, their testimony, or use of our doctors to further delve into exactly what those psychotic features are would be.
No, the question is psychotic features versus he's a psychopath. I
Judge
mean,
Doty
we
said
just
he
a
was
couple of
psychopath.
minutes ago established that there's a difference.
Well, that was never, that testimony was disallowed from day one, just because of and Dr. Burson said he would never, ever refer to somebody as that. That's inflammatory and it doesn't give the proper medical diagnosis.
Okay,
That was
we
never
are,
said in court by anyone.
Judge Silberman and I have helped you use up your time, and so you need to wrap up, Ms. Richards.
Yes, Your Honor. Well, and for the rest of it, we believe that John Chuck has not proven his case here. We would ask you to affirm his sentence, and I will rely on Ms. Parnes' brief for any other questions that I didn't get to. And thank you for your time.
Thank you. Ms. Kopik?
Yes, thank you, Your Honor. I think it's important, even if I use the whole 4 minutes of my rebuttal, to please, please, please urge this court to understand that psychosis and psychopathy are not the same thing. You know, psychosis is not subjective. It is objectively looking at symptomology, delusions, hallucinations. When you see somebody on the street rambling to themselves, they are floridly psychotic, and they very well might score a 1 on the psychopathy checklist and be nowhere near having any psychopathic traits. So this notion that the defense said we're going to rely on the fact that he was in a psychotic episode has literally nothing to do with psychopathy. And I do, if I remember right, one of the defense experts was asked by the state, do you believe he has psychopathic features? Maybe Dr. Otto, I can't recall, and he said he might. Basically, I don't know because I didn't do that evaluation. And why did he not do that evaluation? Because it wasn't relevant to the determination that he was asked to decide, was he not guilty by reason of insanity at the time of the offense?
So, Ms. Kopik, isn't that the point, that the defense certainly didn't think it was relevant, but the state says, well, there is another explanation. He has these features. It's in his reports. Defense doctors acknowledge that he has those features. And now the state's putting on a witness to say those features were the driving factor, not the McNaughton features.
Well, and again, Your Honor, right, in rebuttal, with just new evidence, completely subjective evidence, we're going to prove our theory. You know, they say, oh, we're faced with this hurdle. The objective facts that Mr. John Chuck killed his daughter, who by all accounts he loved and adored, in the presence of a law enforcement officer. So faced with those objective facts, the defense is just going to be able to argue, well, he must be crazy. Only a crazy person does that. Well, okay, so you counter it. Certainly the doctors could have gone on and say, no, it wasn't because he was crazy. Dr. Burson said, oh, he was in and out of reality. He had clear and obvious psychosis, you know, a mental illness. But at that moment on the bridge, I'm going to discount that and say, I believe, my pure opinion is, I believe because of who I think he is, his personality, because of all these horrible things that you've heard, jury, and I'm not going to tell you he's a psychopath, but I'm going to tell you he has all these psychopathic features that I believe that's who he is. So that's just ergo why he did it. I mean, that doesn't open the door when you put your state of mind in. Again, I go back to the self-defense analogy. That would be like saying, oh, you've put in state of mind defense. A law enforcement officer saw the defendant have a gun trained on him, but so that would be pretty dang good self-defense case for the defense. But the state says, but we know this defendant has brutalized people in the past, so he can't have even if he does have a reasonable fear, it's counteracted by the fact that he's just an aggressive person. So you're completely depriving him of that defense. That's what we have here when you have rebuttal of insanity and their own expert is saying, I didn't do it to say he's insane. I just did it to figure out what makes him tick. And then I'm going to say, because of who he was, what he did when he was 5 or 10, that I think that's at that moment in time what he did. And that doesn't open the door to being able to say whatever you want to say. Again, it's relevancy.
And
It's relevance.
That's your 4 minutes, Ms. Kopik.
Okay, if you would, we would ask the court to reverse and remand for a new trial, or at the very least, a Daubert hearing. Thank you.
Thank you both very much. Well
Thank you
argued.
both.
And in order to leave our virtual courtroom,